Get ready for the dictation. Start. We have elaborately dealt with the pleas of the learned counsel for the parties in our order dated 14/12/2018 under the heads of decision making process, pricing and offsets. However, before proceeding to deal with these aspects, we had set out the contours of the scrutiny in matters of such a nature. It is in that context we had opined that the extent of permissible judicial review in matters of contract, procurement, etc., would vary with the subject matter of the contract, and that there cannot be a uniform standard of depth of judicial review which could be understood as an across the board principle to apply to all cases of award of work, of procurement of goods oblique material. In fact, when two of these writ petitions were listed before the court on 10/10/2018, we had embarked on a limited inquiry despite the fact that we were not satisfied with the adequacy of the averments and the material in the writ petitions. It was the object of the court to satisfy itself with the correctness of the decision making process. We cannot lose sight of the fact that we are dealing with a contract for aircrafts which was pending before different governments for quite some time, and the necessity for those aircrafts has never been in dispute. We had thus concluded in para 34, noticing that other than the aforesaid three aspects, that to a limited extent this court did not consider it appropriate to embark on a roving and fishing inquiry. We were, however, cautious to note that this was in the context of the writ petition filed under Article 32 of the Constitution of India, the jurisdiction invoked. In the course of the review petitions, it was canvassed before us that reliance had been placed by the government on patently false documents. One of the aspects is the same as has been dealt with by our order passed today on the application for correction, and thus does not call for any further discussion. The other aspect sought to be raised specifically in review petition number 46/2019 is that the prayer made by the petitioner was for registration of an FIR and investigation by the CBI, which has not been dealt with, and the contract has been reviewed prematurely by the judiciary without the benefit of investigation and inquiry into the disputed questions of facts. We do not consider this to be a fair submission for the reason that all counsels, including counsel representing the petitioners in this matter, addressed elaborate submissions on all the aforesaid three aspects. No doubt that there was a prayer made for registration of FIR and further investigation, but then once we had examined the three aspects on merits, we did not consider it appropriate to issue any directions as prayed for by the petitioners, which automatically covered the direction for registration of FIR prayed for. Insofar as the aspect of pricing is concerned, the court satisfied itself with the material made available. It is not the function of this court to determine the prices, nor for that matter can such aspects be dealt with on mere suspicion of persons who decide to approach the court. The internal mechanism of such pricing would take care of the situation. On the perusal of documents, we had found that one cannot compare apples and oranges. Thus, the pricing of the basic aircraft had to be compared, which was competitively marginally lower as to what should be loaded on the aircraft or not, and what further pricing should be added has to be left to the best judgment of the competent authorities. Stop.